Recording in progress.
There we go.
I think we're on.
Good.
All right. Ready, done?
Ready.
Calling this regular meeting to order on September 8th, 2021 at 7:02 p.m. This meeting is being taken for transcription purposes only, and the written minutes and attachments, if any, will serve as the official record of this meeting. I will now ask the secretary to call the roll.
Calabro.
Here.
Here.
Celeste.
Here.
Mainzer. Here. Bud.
Here.
Schaefer.
Here.
Only.
Here.
In the audience are Trustee Burns and Zoning Inspector Wilson.
And Mr. Walmley is recused. Has recused himself from this. And you have Ms. Mainzer?
I have Julie. Is
Okay.
Julie also?
She's just here as,
Okay.
she's here in attendance.
Okay.
Okay. Let me just for on behalf of the audience, the virtual audience, we ask that the public joining us in person is to approach the podium. In the event that they would like to speak, they will need to announce their name and address prior to speaking. And we ask the audience to save any personal conversations for after the meeting, as additional voices cause confusion for those attending virtually. Okay, we have two sets of minutes to approve. The first set of minutes is for the regular meeting of August 11th, 2021. Has everyone received a copy of those?
Yes. Yes.
All right, are there any changes, additions, any deletions, anything at all?
No. No. No.
If not, do I have a motion to accept them as they are?
Motion to accept.
That's Bill. And a second?
Second.
And that's Jeff. All in favor, say aye.
Aye. Aye.
All right, just going down for a signature. All right, the next set of minutes are for the public hearing minutes for the Petrie Buzzard Cove Screen Park hearing, which was held on August 25th, 2021. Has everyone received those minutes?
Yes. Yes.
Okay, thank you, Judy. They're very comprehensive. And are there any changes, additions, deletions, anything at all on these?
I just got two small spelling.
Sure. Go ahead.
Okay, page 4. Second paragraph, second sentence. It should be Broadview, not Bloodview.
He did say Bloodview.
Huh?
He did say Bloodview.
Bloodview is the name of the,
Yeah, the
name of the
exhibits.
place.
Yeah,
It's the name of the exhibit, not the
It's
city.
in Broadview Heights.
Oh, is it? Yeah.
Yes.
but they
Oh.
call it Bloodview Heights or something.
It's just
Yeah.
play on words. Okay, because we talked about Broadview Heights.
Yeah.
Okay.
Right, but it is Broadview.
Yeah.
Neat,
That was what.
That's the name of.
Yeah.
neat name.
Yeah.
That's the occasion.
Okay, well, we'll try one more then.
Okay.
Page 14. Third paragraph. What's should be what? Fourth word.
I'm sorry, what paragraph?
Page 14, third paragraph.
Oh, I see.
Said should be what guarantees, not what's guarantees.
Yes.
Again, minor, but it's,
Yeah.
no, 1 out of 2, that's not bad.
Okay, if you received these, when Suzanne sent these, there is a change on page 7, and it is the changes made on the ones that we'll be signing. There is a sentence that needs to be added in there regarding, it's the first paragraph, page 7.
Okay.
Ms. Mainzer stated she needs the nets raised. And then the additional sentence is Mr. Petrie in the audience stated that Greg, the owner, was having the nets raised and an engineering firm was being consulted.
Okay.
That was in the recording. I believe that Mr. Petrie was speaking from the audience, so, but it is kind of pertinent so we put that in there. Okay? That is so the change has been made in these minutes. I don't know if you have them.
Got it right here, yeah.
Do you? Okay. All
Here
right.
on this one.
And that's all that I have, and anyone else?
No, quite comprehensive.
Yep.
Good job, and complete.
I'm sure it was wonderful to do this. So, do I have a motion to accept them as, with the couple minor changes?
So move.
That's Dave, and a second.
Second.
All in favor, say aye.
Aye.
That's Bill. And, motion, passed 5-0 on those. Okay. We have an item on the agenda that came in with a letter that was received from Mr. Hunt, Todd Hunt, regarding the Firemax conditional use request AP 0255, which was voted on July 28, 2021. Mr. Todd, did everybody get that letter?
Yes.
Okay. Mr. Todd is asking the BZA to reconsider its vote of July 28th and to rehear the case at this meeting. What we will do, and there's a couple reasons that he states, and I can let him read his reasons. What we will do is we should have a discussion regarding reconsideration. We will not be able to rehear the case this evening. We can have a discussion regarding the consideration, and then we can take a vote if we want to reconsider it. If we do, it will be heard at the next public hearing or at a special meeting date that we determine. So at this point, what I would like to do is maybe to have, if Mr. Hunt would like to step up and just give us the reasons that you have stated here that you would like for us to reconsider.
Thank you, Madam Chair, and thank you, board members. I was brought in sort of late in this this matter, and when I reviewed the minutes, and by the way, I do represent both Tire Max of Ohio and ML Woolney Properties LLC, the owner of the property. When I read the minutes from July 28th, I did not have a clear understanding of what services were going to be offered at this particular proposed facility. And I don't think it was very clear. And I do know that some of the board members had actually tried to put into evidence some findings that they had made. And so I would like the opportunity for my client to actually present very clearly, concisely, exactly what services are going to be provided. And I feel that those services that will be provided fit within your zoning resolution regulation and the definition of automobile service station. I think the other really important thing is that at a previous meeting before July 28th, I know that the board requested a consultant's report, and that report that I got and my client got was several days after July 28th. We got a copy of it, and we saw that the consultant had at least made a finding conclusion that was, I thought, favorable to us in terms of the types of services that were being provided that fit within the conditional use provisions of your zoning resolution. And I think it would be important for us to put that on as evidence in support of our application. So those are really the two reasons that I'm putting forth for reconsideration. And I would ask that you do move this evening to reconsider, and that it's fine, set a new hearing and we'll come in. I don't think it'll take very long, but also I've got a deadline of Friday that I have to file in court, an administrative appeal of that July 28th decision. And I'd prefer not to do that, but I'm going to have to do that on behalf of my clients if this is not reconsidered.
Okay. No, I have to interrupt you because I did forget to swear you in. And
Oh.
I probably should have sworn you in after you.
Well, you can swear me in now, and I will affirm, I will also affirm everything that I said is the truth. So
Let's just do it. I please state your name.
I, Todd Hunt,
Swear to tell the truth, the whole truth, and nothing but the truth as you shall answer.
I do.
Thank you so much.
And everything that I have said previous to taking this oath is true, and I'll certify that as being true. So those are the reasons. I thought my letter was pretty self-explanatory,
It is.
I would hope that you would reconsider.
Okay. The reason we can't, you obviously know the reason we can't rehear it tonight is.
I understand that.
We do have to
I certainly do.
There has to be enough time to be.
I-
and all that, so.
I've been a law director for almost 40 years. I attend zoning board meetings monthly in several communities that I'm law director in, and I have represented townships in Medina County because I lived here for 24 years. So
I just have a couple questions myself, and then I can let loose whatever you guys have. But I mean, what you say that you're going to, and I don't need any evidence to be presented this evening, but you say here that you're going to clarify or that we didn't have a clear understanding of the services that were proposed. I mean, this is a use variance, and I mean, what's new about the use?
well, it's a conditional use permit. It's not a use variance. So
I mean, is there a significant, substantial change from what was originally presented?
when I read the minutes, it was not clear exactly what was going to be done here. Now, maybe that was Mr. Leiden's, part of it was his fault. I know that couple of board members put their thoughts and evidence on, which, and I would like to clarify exactly what's going to be done in this thing. Because when I read the minutes, I didn't have a clear understanding of what was going to be done here.
Okay. And then the second thing that I just wanted to address was the OHM report. Did everybody on the board receive the report?
Yes, yes,
Did everybody on the board consider
yes,
the report, review
Yes.
it, and consider it as part of the decision?
yes.
So even though we did not mention it during the hearing, in the minutes, we did not read it into the record, it doesn't necessarily mean we didn't consider it. And of course, what the report says is up to interpretation to each member.
I understand that the Board of Zoning Appeals interprets the zoning resolution, but you did hire a consultant to give you advice and an opinion on that. I think it's important. And I think the more important thing is that we were not provided a copy of that prior to that hearing, which I think is pretty important. It sounds like it was provided to the board that day because the date on it is July 28th.
Yeah, it may have been before.
And so I think that's very important that we didn't have the opportunity to present that. And it's not even in the record of the Board of Zoning Appeals.
But I mean, that really wasn't part of your.
It certainly would have been had we known it.
No, but I mean, it was for our consumption
Sure.
to
Yes.
consider the report and, in making the decision.
Right. And I think it was incumbent upon the township or the Board of Zoning Appeals to provide it to us prior to a decision being made. Because I do think it's helpful to us.
Okay. That's all that I have.
Did you, go ahead. Did you read the minutes from both meetings or just the one?
I believe I saw the minutes from the earlier June meeting. But I did look at them at one point in time, but I obviously thoroughly read the July 28th.
Because I thought it was pretty well laid out of what the services would be in between the two meetings. Personally, I thought.
Mhm.
And
I did not get that impression. I really didn't.
because I mean, we went back and forth, telling what we thought, and he came back and said, well, this is what we're going to do and what we're not going to do, my opinion.
Okay.
I thought I was pretty clear on what the services were going to be, plus looking at the websites, it pretty well laid it out.
Yeah. Well, I think the website lays it out pretty well.
So I'm just wondering what new
It's just,
interpretation of the services would be brought up for us to rehear this.
I don't think there's any new interpretation other than what is on the website for the other two stores. I think that's what this store wants to do. The issue, though, is that a lot of those things aren't really done or done very often. But the list of services is what's on that website.
Mhm.
They don't do major transmission work. In other words, they don't replace transmissions. They fix transmissions, but they don't do that very often. They just don't have the space in a little 6,000 over.
Yeah, we're not getting it, yeah.
Yeah, and the
I'm
other,
just wondering.
the other thing-
new evidence.
major edge-
I thought it was pretty well laid out. And as far as the OHM report, I took that into consideration the way I saw it,
Mhm.
but I'll leave it up to,
Well, we'll take a vote on it. We can make a motion to reconsider it or not.
Yeah, I just would like to clarify. Are you saying we use the documentation that was submitted plus the presentation that was made during the meeting
Mhm.
to make our decisions? Are you saying that there's a gap between what happened in the meeting and the minutes?
I'm not saying the minutes are not accurate. I'm sure, I'm sure your secretary does a fabulous job.
Yes.
It was just when I read the minutes, I could not get a clear understanding of, and I couldn't get it. I didn't know if the board was able to get a clear understanding of what those services would be.
Well,
That's my
the
point.
documentation, what was lacking in the documentation that you didn't think we
Well,
understood?
I'm not sure you actually got a whole list of services on paper is what they were, which I think is important.
So are you telling us there was information missing from your presentation and documentation?
Well, there may have been, yes. The questioning back and forth to Mr. Lydon, the presentation by, I think, two board members as to what they had found on their own, to me was very confusing as to exactly what was going on. So I'd like the opportunity to clarify that.
I guess what Mr. Budd is trying to, what Bill is trying to say, which I have the same question, like, is that the board's issue that we didn't understand what was being presented, or is it that?
I don't think you understood. I don't think you understood what was being presented, and part of it may have been the way it was presented. I'll have to say that.
Well, I think if you are telling us that there's substantial or significant information that was not presented for us to make an informed decision, then, I mean, you have your choices you already stated are one of two. One is we stick with the decision that we made,
Mhm.
file an appeal.
Mhm.
Second, you can reapply.
I'm not
Submit
sure.
a new application, maybe you can do that. Submit a new application with new information.
Well, I'm a lawyer and I've been doing this for 30 years, and I don't think I legally can submit a new application.
Why not? If it's different. I think the main thing is this report from your consultant. That was not made part of the evidence. I would have made it part, our clients would have made it part of the evidence, and it was not. And it's helpful to us. So that's the main issue I'm asking for reconsideration on. Because when you file the record with the Medina Common Pleas Court, you're not going to be filing that report, I assume, because it was not put in evidence at the record, as part of the record. And I've got to have it. It's a key piece of evidence, I believe. It's a key piece of evidence the way you interpret it.
Well, of course.
We interpret it. Well, actually, it was a 3-2 vote.
No, I understand. Yeah, I know that.
So obviously, you're concerned about the 3 that voted no as opposed to the 2 yeses, because if they had 5 yeses, we would not.
That's
So,
true. If we had one more yes, we wouldn't be here. So.
Yeah. So it is a matter of interpretation, how we interpreted the report. I do agree with you that maybe it should have been in the record. However, it doesn't mean that we did not consider it just because we didn't mention it.
Well, if you considered it, it should have been in the record. And we should have had a copy of it on the 28th of July. We didn't get it till August 4th.
Do we have an avenue for reconsideration? I don't see that anywhere in
No.
rules and
We don't have
regulations.
anything in the
No, that's what I
statute as far
say.
as reconsideration. Basically, I mean, we're gonna make a motion to see if we want to reconsider this. But I mean, the 2 options that are available. Let me put it this way. I was called last Tuesday, and I think your letter came on Wednesday to us. And I was called to see if I wanted to just make the decision myself whether we're going to reconsider it or not. And I didn't think it was fair for me to just.
No, you wouldn't. Yeah, I understand
So
that.
I wanted the board to have a discussion and have a vote on
Mhm.
it. I feel that you have the option to file an appeal if you didn't like our decision. And the second option, which you say you cannot do, if you have substantial new evidence or substantial, it can be presented in a different way, you can reapply.
Well, I've been doing this for almost 40 years, and I'm not sure I could do that in this circumstance. But
So that, I mean, those
if
are-
you'll let me do it, maybe I will. I don't know. So.
well, Tom, have we ever had someone submit a new application?
Not in the last 6 years that I've been on zoning.
Okay. I asked Suzanne, and it has been done. Suzanne being our secretary, it has been done.
And
But again, it has to be a different, there has to be substantial changes. And
Correct. We're not going to change anything in our proposal, that's for sure.
Well, you're not changing anything in your proposal, so it's just a matter of how it was presented to us. That you're going to clarify so that we can understand it better.
Well, you're focusing on that more than you're focusing on this report from your consultant, which you commissioned at a previous BZA meeting on this hearing, and we did not get a copy of it and it was not presented into evidence. I think that's a major issue.
But, the way you're presenting it is this report says it is a definite yes, that this is a permitted use. That's not what the report says.
Well, it does say that. It does say that this
Well,
is
again,
permitted and conditional.
Maybe we got a
Ours
different, maybe we got a
permitted.
different report then.
No, I don't think so.
Yeah.
But again, we can,
Okay.
do you have anything else to add?
No, I don't have anything else to add, and I do thank you for your time.
Thank you. We can make a motion to, and actually, do you want to do it or? do you want
Well,
to do it?
I mean,
Oh, yes, okay, yeah.
before I vote yes or no, I got to know if it's something that we can do. I mean, if it's something we can't do, it'll be definitely a no. But if it's
As far
something,
as a reconsideration,
Procedurally.
is it built into our
we
system?
can.
Mhm.
I mean, it is not a typical thing that we do. I've been on this board over 10 years. We've never
Well,
done
like I
that.
said, I've been doing it for 40 years. This zoning, land use, been advising boards of zoning appeals for 40 years.
And
I actually give seminars, and I have for
so, and we can,
40 years to people like you. And there is ample case law in Ohio that says within that 30-day period, you can reconsider your decision. After that 30-day period is up, you cannot. That's why I'm here this evening.
Well, that would be the first for me in 30 years, because we've never done that in 30 years here.
it doesn't mean we don't have to do it,
But that's true.
Madam Chairman,
Yes.
didn't our legal counsel tell us that we could do that when we talked to him? Brian Richter?
If we vote on it, I mean, if we, as a board, decide to reconsider it, we can.
Well, I talked to Brian myself, and Brian said the same thing, so
Right.
agreed with me. So.
It's up to us.
Now, is this a separate hearing,
Well, we would
another,
have to
is
do-
there another fee on this or?
Yes. There
That's
would be
fine.
a fee, but I mean, that's an administrative
Right.
thing.
That's fine.
But,
Sorry about that.
it would be, we can accommodate the applicant by doing a special meeting or pushing it off into, we're talking end of October, whatever because it's too late to do it for the end of September.
October, your October meeting would be fine.
Yeah, so it would have to be, we're talking October 27th.
Okay.
Or we can, if we decide to do a special meeting that needs to be done sooner, if we vote yes on the reconsideration, then it can be as soon as September 29th. We could hear the next regular meeting of October 13th, October 6th, because we would have to give public notice. It would have to be published that this is happening.
Well, my opinion is that, if they believe that this report should have been mentioned and that they had a right to it, I'm not 100% sure whether they did or not, because it was our report at our request. I think we should possibly err on the side of caution and give them the rehearing. But as far as the other point that he's making, that this wasn't presented to us as to what they're doing, I think with the way we questioned and with the answers we got, I think it's very clear what that was. So it's kind of a split decision right there, you know, but that's all I have to say about it.
Let me, I would say the normal way of approach, if you disagree with our decision, which is what I think you're doing, an appeal would be the appropriate way to go. And that's happened in the past a number of times when there was some disagreement or dispute, if you will, over the way we ruled and how we ruled. So it seems to me that should be the accepted way of handling this situation.
Anyone else or anything else?
No.
Okay.
Nope.
Anyone else? So can we, do you want to do the motion or do you want me to?
I'm just gonna get the AP number.
It's on there.
Oh, okay. All right, make a motion to hold a public hearing to rehear the case and reconsider the BZA decision of July 28, 2021 on Tire Max conditional use request AP 0255.
Second?
I guess I should explain that a yes majority, you know all that, right? Okay. So yeah, let's do it.
Calabro.
No. Who?
No.
Selesnik.
No.
Schaefer.
No.
Todd.
No.
Thanks for your time.
Motion denied, 5-0. And the last thing that is left on the agenda is to remind of the regular meeting that we have coming up on October 13th. And anyone else have anything to contribute?
Nope. Nope.
All right, if not, do I have a motion to adjourn?
So moved.
Second.
Schaefer, Bill. We are adjourned at 7:30 p.m.
Recording stopped.
Leave meeting.